Hi class and hi professor. Today I'm going to talk about the rights releases of modeling contracts. Okay, so what's a model release? A release is a model's permission for someone to do something with her or him likeness that they could not legally do without her or him permission. And this is usually where the models are asked to sign a release of rights to the photographs by the photographer. The releases are usually designed to protect the photographers and to give them the ability to use or distribute them in any and every way they want. So what are some rights that the models themselves have? In general, there's two types of rights that models can have, which is the rights of privacy and the rights of publicity. However, these rights are not recognized in every state, or they vary from state to another. And by signing a release, you may, the model may waive, if not all of these rights. So the rights of privacy include intrusion upon seclusion or solitude or into private affairs, public disclosure of embarrassment, private facts, publicity which places a person in a false light in the public eye, and appropriation of name or likeness. And now talking about the rights of publicity, unlike the privacy rights, the rights of publicity is a property right. It says that you own the value of your image and that you have the sole right to exploit that value. A little bit more about that. As an increasing number of states, like in California, a famous individual has additional rights of publicity, which is the right to control how his image or his fame can be exploited for commercial purposes. And that's where you hear the term defamation or defaming someone, where a lot of lawsuits they come about this subject matter. This is unlike the rights of privacy, which deal with the persons to whom they belong. The rights of publicity survive their owners and can be passed along for generations. Rights of publicity also tend to be more specific in their prohibitions than the rights of privacy. Here is some facts about the models and the photographer legal relationship. After release, the photographer had the sole right to use the photographs, even if they were of a certain model. Basically means the model could not use these photographs for her own without a permission, and the model cannot publish, not just use these photographs that was taken by a certain photographer, especially if you have a signed release. Otherwise, the model must obtain a permission. And if the model did not get paid, it does not null the release unless the release states so. So in this case, the photographer still owns the photographs even if he did not pay the model. So that's why most models must pay attention to the significant clause actually in their releases. And each state has its own law regarding privacy and public rights or publicity rights. Models and photographers are encouraged to check them out because it varies from state to another. Some they recognize, some they don't. So someone need to realize what they get themselves into before they do it. So that was my piece, and thank you so much for everything. This page is for citation. Have a great day, and I'll talk to you later.